All right, well, it's 8 a.m. Thank you all for being here today. What we'll do is, if it's all right, I'll go ahead and open us in prayer, and then we'll kind of give an overview for today and proceed with bill consideration once we're able to. So if you'd please join me in prayer. Dear Heavenly Father, we ask you please look after all of us here today and our work here on Capitol Hill on behalf of the people of Georgia. Help us to live in your way. In Jesus' name, amen. All right. The committee has an agenda here today, but what I'd propose, members of the committee, is just to outline our agenda for today, and then we can kind of move into the order as we need to, and I see some members are coming in. We had a Supreme Court opinion this past Monday, President's Day, that made very clear that Georgia law is unconstitutional with respect to allowing the admissibility of a refusal of a breath sample in a DUI stop. And so I anticipate that we're going to have several hearings over the next few weeks to look into this issue. And what I'm proposing for today, or I've requested, is Legislative Counsel to give us a summary of the Elliott case so that we can really isolate the issues. And then also I'll ask the GBI to provide a summary of how this might impact them. So, okay, so at this time we'll go ahead and move on to, we have a quorum, so we'll go ahead and move forward with the bills that are in the folder. And is the substitute here on, is that coming?
That one is not in the should be.
Here it is.
No, this is 281. Substitute for 281.
Yeah, which was, this is what was passed out of your subcommittee.
Yes, and then this one.
Pass some of these down. All right, so what I propose to do is to call HB 281 first. And there's actually a substitute that was passed out of the Reeves subcommittee yesterday. So this is LC 289222S. So I'll call Representative Anulowicz forward to present her bill.
Good morning, and thank you so much, Chairman of Administration. I'm glad to be here today. There is a substitute being passed around. If I could have a copy of that also, actually, that would be fantastic. Thank you. This is hot off the press. But 281 is a very simple bill. What this does is makes a couple of changes to Code Section 16611 and 16612 regarding pimping and pandering. Right now, it basically makes it so the first offense for for pimping, which is 16611, is first offense is a misdemeanor of a high and aggravated nature. They up to 72 hours of any imprisonment can be suspended, stayed, or probated. Second and subsequent offense, and actually this language should have been changed to reflect second and subsequent offense.
Ooh, that's right.
In the substitute. That was the amendment that passed.
Yep. It's offense says.
Yes, second and subsequent offenses is how that should read in line 20. Shall be guilty of a felony and shall be punished by a term of imprisonment of not less than 1 year or not more than 10 years. And then that same change should be reflected for Code Section 16612, and that should be in line 26. Second and subsequent offenses shall be guilty of a felony and shall be punished by a term of imprisonment of not less than 1 nor more than 10 years.
I think grammatically it is offense, if you read the full sentence. It starts up there at the top with a second or subsequent offense, is the way it's worded.
A second.
That is right.
Okay, you're
Yeah.
absolutely right. So scratch the S.
All right, are there any questions for the sponsor this time? All right, is anyone signed up to speak? Oh, excuse me, Chairman Setzler.
Thank you. The sponsor, thank you for this, and we had some good discussion in subcommittee about the balance here. The 24 to 72 hours, I think we discussed a friendliness to that as a subcommittee. How do you expect this to play out in practice? Does this mean upon arrest the person's going to spend 72 hours in jail, or is this going to mean upon conviction they're going to have some time to serve? How do you, as a practical matter, in a misdemeanor setting, how do we think this is going to actually play out in execution?
Well, I know that right now the way it typically plays out is if you're arrested for pimping, for example, you do spend 24 hours in jail, and that is really what led that is really the origin that led to the inception of my taking on this legislation, was speaking with the FBI Match Task Force that does a lot of work in Cobb County and throughout Metro Atlanta to bust up some of these prostitution rings, and they said that it's really been a hindrance to them because pimping is always is a misdemeanor no matter how many times you pimp. Unlike other offenses like shoplifting, for example, where you do reach a point where it becomes a felony, pimping is constantly a misdemeanor. And we have pimps, and actually I had Detective Meredith Holt here from Smyrna Police Department, who works with the FBI Match Task Force, who talked about pimps she'd arrested, who said we view this as a cost of doing business. And so I think the intent is to eliminate that aspect of our current law being an inconvenience to these pimps, and really putting something that has teeth in it, so that number one, we are actually addressing this issue, but two, we're not constantly diverting resources, law enforcement resources, that need to be given towards other things, and especially human trafficking.
Yeah. And Mr. Chairman, I just was asking too, because think about on the pandering side, spending a night or two in jail probably is a big hammer. On the pimping side, do we do well? And I guess this is perhaps a question of the committee. Do we have enough financial hammer in this? As it's crafted with a 1 to 10 felony, I know there's no, do we do well to put in a stated penalty? And another question I simply don't know the answer to is by virtue of putting it here, is this subject to civil asset forfeiture? I certainly am a believer that the bar for civil asset forfeiture ought to be higher than it is today in Georgia. It's a principle. But by virtue of being in this code section, if there's a pimp that's got property, automobile, whatever, is that subject to civil asset forfeiture by virtue of being in this part of Title 16? Because again, to me, to the author, the financial hammer on the pimping side seems to be as strong as the criminal hammer. These are people that would probably have a record, and I just want to make sure that's something that we can.
I think we actually should have an answer to that shortly. Mm-hmm.
I know that
Mr. Scandalakis, would you just move up to microphone, please, and hit the button so we can, because this is on TV.
I know that we're looking up the question about the civil asset forfeiture, but I also know that as a matter of evidence, you could keep any amount of cash that you can trace back to the transaction, that you would be able to keep that as evidence, and then eventually have the court decide what to do with that cash.
I just know General Assembly is in circumstances of different commercial crimes. We've stated an amount of financial penalty. To me, on the pimping side, the financial hammer is more of a hammer than spending 3 nights in jail, perhaps. And I just asked the question: does this do enough to focus on that issue? And do we? Because to me, if we're taking people's cars for some of the things we take people's cars for, and property for civil asset forfeiture, to be sure, we do not need to miss that opportunity in this committee to lower that boom.
I see legislative counsel with his finger up.
I just want to caution the committee in light of the United States Supreme Court decision earlier this week regarding civil asset forfeiture to tread a little slow in this area, because they say it may violate the excessive fines provision of the 8th Amendment if we go after them, a fine that's disproportionate. For instance, if you have a fine for a crime that's $5,000 and you take $30,000 worth of property from the person, that the court may see that as very disproportionate. I'm not questioning the policy. That's you to make a decision. I'm just saying you might want to tread a little slow in this area until we get a little more refinement on what is proper and what's not proper with civil asset forfeiture.
And I'll interject also that in the conversations that I have had with several of the law enforcement officers who work on these cases, I think that 3 nights in jail for a pimp is a tremendous financial impact that goes far beyond a fine, because that is 3 nights that they are not working, basically. I mean, it is definitely a financial impact. And I am keenly sensitive to these issues of civil asset forfeiture, and I agree that there should be a higher
But
fine.
losing a $26,000 Trailblazer SUV or whatever it is they operate with, I don't want us as a committee to if it's a tool we use in the state for other things that we would deem to be less egregious than a 1 to 10 felony pimping, I don't know why we would not include that
I
in this.
believe it is included. So, Mr. Scandalakis.
We do have that ability
Yes,
to do that.
Okay.
And since 1994, there's been a decision in Georgia. We have the Indiana decision that legal counsel refers to. We've been doing that since 1994. We recognize civil forfeiture shouldn't be used as excessive fines. So Georgia's had that on the code since, and case law since 1994.
My recollection is for these offenses, it was in the 2016 SB 8, as I recall. And I don't know, but this offense was included in the forfeiture code.
We do have it, though.
Yes, sir.
We have that ability.
All right. Thank you. All right. Are there any other questions from, is it all right if I ask it? Are there any other questions from any members for the sponsor? All right. And I don't know if we had a sign-up sheet out. Does anyone have any questions in the audience or wish to offer testimony at full committee? I know there were 2 subcommittees on this bill previously. All right. So at this point in time, I'll call on the vice chairman, who was the chairman of the subcommittee, to give the subcommittee report.
Thank you, Mr. Chairman. This committee is familiar. Everybody that's returned from last year is familiar with this concept. We had a Senate bill come across last year that looked that we got through this committee that almost it may be identical word for word, and so there was a lot of familiarity with the concept here. But we did what we always try to do, and that's try to balance the policy and into appropriate reasonableness. And I think that we landed where we did last year, and the committee very favorably passed this bill through.
All right. Thank you for the report. At this point in time, I'll accept a motion.
Move to pass by committee substitute.
Second.
All right. So there's a motion to pass by committee substitute LC 289222S and a second. Are there any amendments? I'll recognize the vice chairman.
Yes, Mr. Chairman. I would make a motion that we amend on line 20 after the word second, insert and subsequent. And the same amendment on line 26 after the word second, we insert and subsequent.
See, legislative council.
I'm just curious because I thought I made that change last night for the subs. I'm kind of baffled why it's not in there.
Okay. So there's a motion or there's an amendment that's been moved. Is there a second for the amendment? All right. Any objection to the amendment as outlined by the vice chair? Hearing none, then the amendment is adopted. Are there any further amendments, any discussion or questions with respect to the matter before the committee? All right, hearing none, then I will call a vote on the committee substitute as amended, LC 289222S. All those in favor signify by saying aye.
Aye.
Any opposed? All right, it passes on to rules. Thank you very much.
Thank you very much.
All right, very good. So I see Chairman Dollar is present. Chairman? Oh, he was. Maybe if we can call him in, please. All right, Chairman Dollar, if you wouldn't mind being front and center here, we'll call HB 341 LC 289140 to be heard by the full committee at this time.
Okay. Thank you, Chairman. Sorry, I was next door talking
No
to
problem.
Fleming.
Good morning.
So, HB 343, if it looks familiar to you, 341, if it looks familiar to you, because it is, this is the same bill that was passed out of this committee, overwhelmingly led by the full House last year. It made its way through the Senate and just ran out of time on day 40. Very, very simply, this bill currently, under current law, if you copy a CD, tape, sell it that's a crime. It's not if you do it on an electronic storage device. This just expands it to include electronic storage devices like hard drives, thumb drives, and I mentioned yesterday in subcommittee, this is in federal code, it's just not in state code. That's the measure for the committee.
Are there any questions for the sponsor? All right, hearing none, would anyone like to speak about House Bill 341 as introduced? All right, I don't see anyone here. At this point in time, I'll call on Chairman Reeves, who was standing in for Chairman Setzler yesterday, to give the subcommittee report.
Thank you, Mr. Chairman. This is essentially just a common sense update to a law. As technology has progressed, this statute doesn't cover the way that most people sell or distribute, bootlegged items or whatever we want to call it. And so this just brings us into the data device age. So it's just a common sense technology update, and it was received very favorably by the committee.
All right, any final questions? All right, at this point in time, I'll take a motion.
Move to pass.
Motion do pass by the minority leader. Is there a second? And there's a second. All those or any discussion amendments or questions? Hearing none. All those in favor signify by saying aye. Aye. Any opposed? All right, passes. Thank you. Thank you. All right, the next substitute that's out to you right now is a substitute on House Bill 259. This is LC 289237S. I don't see the sponsor present here. Did we have a report from her this morning?
I haven't spoken to her this morning. I think I can. I mean, at your will, I can.
Well, I'm comfortable proceeding without the sponsor. I'm comfortable proceeding without the sponsor if unless there are questions, of course, for the sponsor, because it was presented at subcommittee in similar format. And there were actually 2 subcommittee meetings on this bill, as I recall, and so we'll see how this goes this morning. But under the circumstances, I'm all right with it. So at this point in time, I will recognize the vice chairman.
Thank you, Mr. Chairman. This bill was filed by Chairman Ballinger, and she is a member of the Sex Offender Registration Review Board and has been very involved with that organization for many years. The review board does several things, and part of what their determinations are is what level someone is placed on the sex offender registration, and petitioning to come off of the registration, etc. And one of the Georgia law prohibits the Sex Offender Review Board from being able to access what we call GCICs, Georgia Criminal Information, which is basically your criminal history. And this information is really essential to determining, number one, what level that is appropriate to have someone on the registration, and number two, what the fair consideration is upon removing someone from the registration. And so this law would allow this bill would allow the Sex Offender Registration Review Board to access his criminal histories. I don't think that concept received any pushback from the committee, but what the concern was is how do we kind of button up to ensure that the Sex Offender Review Board does not have there's prohibited from distributing that criminal. Obviously, criminal information is sensitive information and is strictly prohibited to be distributed. So this, what was added in was this on line 21, as the words as defined in subparagraph A of paragraph 4 of Code Section 35-3-30, which is the code section that deals with the prohibition on distributing GCICs. And so that just buttons up and ensures that they are mandated that they cannot pass that information along to anyone else. And I believe that there's I may be confusing this with something else, but there may be a process where they even destroy it after certain time. And am I right about that?
Ask Ms. Miles if you're willing to testify on this, or if the GBI has any comment on that. Thank you very much. If you would just, perfect. So I'd ask, just one of the mics over there is active so that we don't have the reverb. Thank you.
That's right. We worked with Chairman Ballinger on this, and everything that we have set up in place, we will leave one person at the GBI. So if they want something outside of the state of Georgia, they'll be able to have access for that. But my understanding is SORB has everything in place to be able to maintain the records and dispose of them properly.
As required by law.
As required by law.
And so as I understand the bill, we're really just allowing access to the Sex Offender Review Board to run criminal history so that they can determine what the criminal history is of the offender.
Yes, for them to have access to it. Right now, those analysts are at the GBI, and as was described yesterday, they were moved to the GBI because they were having some trouble, getting, I guess, kind of the credibility since they weren't law enforcement. And now that their name is out there, people know who they are. They're going to have those analysts go back to SORB, and we'll maintain one person at the GBI.
I think her comments are appropriate to 260. This is 259. This doesn't deal with moving. This is just the information. I want to make sure.
Yeah, but I guess, I kind of view them kind of a companion because they want that.
This bill just doesn't talk about that moving the analyst. That's the reason I'm pointing.
But that is covered in the companion.
Scandalakis.
Generally, GCIC information is destroyed after it's viewed, and most of the time it's not subject to open records. Now, GCIC has its own set of regulations that before you can even look at a GCIC, you have to take a training course. You take that training course, and all of that information, particularly on the criminal side. Of course, you can run a GCIC for business purposes, employment purposes, but all of that is confidential information and is not subject to open records.
All right. Any final questions for members of the committee for either of the witnesses or for the vice chair? All right, I don't see any lights. So at this point in time, a motion will be appropriate. There's a motion to pass on 259 as substitute as amended, LC 289237S, and a second. Any discussion, questions, amendments? Hearing none. All those in favor signify by saying aye.
Aye.
Any opposed? All right, it passes. Thank you. All right, at this point in time, our committee is going to continue, and what we're going to do is, Ms. Miles, if you'd like to, since you're up here, maybe we can start with you, if that would be okay. So, excellent. Yes, any witnesses can join you that you'd like, and just sit where you're comfortable or have your materials out. But I'll just begin by saying, for the benefit of any members who weren't here earlier, on Monday, the Supreme Court of Georgia issued the Elliott opinion, and the impact of that is something that this committee, I expect, is going to analyze over the coming weeks and days. And what I thought we'd do is begin this morning with a report from the GBI and also from Legislative Counsel to summarize the case. I know it's a fresh case. I believe it's around 90 pages, the opinion, and with the concurrence. And so I know it's a lot to read. And to just get right to it, if any member isn't as familiar, my understanding and concept of things at this point is there remains the availability for law enforcement to seek a search warrant for a blood draw in the event of a refusal. And so the question is then, if that were to be pursued, who is testing the blood, and what is the turnaround time for that? What might the implications be of that additional workflow, work to be done as a result of that potential option? And so at this point in time, I'll recognize Ms. Miles, and please feel free to recognize any other witnesses as you or any others give testimony. Thank you.
Okay. Absolutely. Well, what we did was we went back and looked at the crime lab in terms of what they're currently doing and what the implications could be. So I'm going to actually turn it over to the individuals that did the research. Have with us here today from the GBI, Dan Kirk, who is our assistant director, and Chris Tilson, who's actually the manager of the implied consent section in the crime lab.
All right, thank you.
Thank you for having us here today, and thank you for allowing us to comment on what the effects of this might be, because it will be pretty tough for us. Probably for the last 40 years, we've had a viable breath testing program, and as such, that is part of the way we do business in terms of DUI. So it's an integrated part. So if we were to take that out, obviously it's going to be a huge gap. And these numbers that I'm going to give you are round numbers. So in 2018, we did approximately 20,000 breath tests across the state. Should those breath tests be turned into blood tests, then obviously that's going to increase our workload within the laboratory itself. So last year we did approximately 9,000 blood tests within our laboratory. That section is manned with 5 people who do that full time. So if we increase our blood alcohol testing by 20,000, those number of breath tests, then we're looking at an additional need of 10 employees to do those tests. We do not have the capacity in-house now to do that number of tests, so it would take 10 people at a cost of about $1 million. 10 additional people. That's correct. So along with that, obviously there are going to be equipment needs. We calculate that it would take about 9 more blood alcohol instruments to do this additional testing at a cost of about $1.1 million. In addition to that, about 17% of blood alcohols are below 0.08 blood alcohol. That automatically triggers a check for drugs. So if you take that 20,000 number by 17%, that leaves about 3,400 check for drugs that will have to be done. Currently, we do about 7,400 of those with the staff that we have. This additional 3,400 check for drugs will require approximately 12 more toxicologists at a cost of just over $1 million. So that's 12 additional toxicologists to do the check for drug tests. Instrumentation for those 12 toxicologists, approximately $1 million. So all total, you're looking at about 22 positions at a cost of approximately $2 million annually. New equipment, which will be one-time cost of about $2 million, for a total of about $4 million for us to be able to do these 20,000 additional cases for blood alcohol and check for drugs.
All right, thank you, sir. Sir, is there anything that you want to add?
Not this time, thank you.
Okay. All right. Well, I appreciate the testimony today. I know my interest certainly was in just getting an idea of what your expectations were without really drilling down into the numbers. That wasn't the objective here today in my mind. But certainly if there are any questions from any members of the committee for the GBI. Yes, sir. Representative McLaren.
Thank you, Mr. Chairman, and thank you so much for being here. Appreciate for sure the difficulty that the Supreme Court ruling could cause. You just, in presenting those numbers, made the assumption that breath testing would be removed from your arsenal tools.
That's correct. That's worst case scenario.
Worst case scenario, right. So I'm wondering, do you have an estimation of, because I guess the right here is to refuse, and then that would not be admitted in court is my understanding. Mm-hmm. So do you have a sense of how many people still would not refuse, would do it voluntarily despite the court's ruling, or has anybody given any thought to that yet?
I don't have any sense of that. Pete? You guys?
We have no idea how many people would consent to it without implied consent being read.
Sure. I guess the reason I ask is just because I figure, I imagine some people would want to take the test not thinking they were over or thinking that it would vindicate them somehow. And so that would be information I'd be interested to hear about, because it obviously would cut into those numbers somewhat.
Any other questions? Representative Setzler.
Thank you, Mr. Chairman. As I saw this, and I've not read the 90-page opinions, forgive me, I'm still in the digging through this mode myself as a member of the committee. Do you have any statistics of people that have refused, but yet then a warrant was then obtained to draw blood to perhaps involuntarily to obtain evidence?
Wow. No, I have no way of knowing that or collecting that data. I mean, it's going to be statewide, and every jurisdiction, every agency is going to be. There are over 600 agencies in the state, so everyone's going to be different.
I'm just concerned with at a minimum the unsightly history of that, and at maybe a fuller way just a broader public policy concern about what unintended consequences or what second and third order consequences could come from this. So I thank you for that.
All right, Minority Leader.
Thank you, Mr. Chairman. And I'm not sure who whether this question is directed to you or someone else out there, but has the GBI issued guidance to law enforcement agencies about how to handle roadside stops in light of the decision?
No, that information is probably going to come from PAC, giving them some guidance. Pete, do you have any comments on it?
We have, and as well as the Department of Highway Safety has as well. And I believe the Solicitor General's have it. And the Solicitor General's have it as well.
And Mr. Chairman, I don't want to get into if it's proprietary or that's a comfort level, but I just want to know for purposes of this committee, tell me what the difficulties are with the guidance issued and how can this committee help?
Mr. Minority Leader, if it's okay with you, I'd like to call C.R. Chisholm up here. He is the Solicitor General for Athens Clarke County and has worked extensively on this.
So this would be my request, if it's all right, to the gentleman. What I'd ask is that we hear from Legislative Council. I kind of went out of order here. I'd ask that we hear from Legislative Council with a summary of the opinion for the members, and then we'll proceed maybe with testimony about how to react. So I'll recognize Mr. Lanier. Thank you.
Thank you, Mr. Chairman, members of the committee. This is, as you've noted, a 91-page opinion with a 3-page concurrence that probably provides a lot more understanding of the case than the 91-page opinion does. There's about 2 pages of procedural and factual summary. There's about 2 pages of holding, and there's about 87 pages justifying the Supreme Court's view of the Constitution and their interpretation of it. Bottom line is, in Georgia, our protection in our Constitution against self-incrimination has been traditionally read to be broader than that of the federal Constitution. The Fifth Amendment of the United States Constitution has been pretty well limited to communicative or testimonial type communications that really do not deal with actions. Actions are not really under the Fifth Amendment. However, under the Georgia Constitution, you can't be compelled to do things that would cause you to be incriminated. And that's where the Supreme Court kind of hung their hat, because when you ask someone to provide a breath test, you're asking them to blow into a tube, an act that would make them actually do something that could potentially incriminate them. As distinguished from a blood test, in which it seems like that would be more invasive, but the courts have found that when we do blood tests, the defendant has to do is just show up. And we do whatever it takes as far as action. The defendant does nothing to incriminate themselves. Similarly, there's a difference between taking, for instance, a defendant's shoe to see if their shoe fits into a track at a crime scene and making the defendant actually step into the track and compare it. The first one is okay because the defendant did nothing. We took his shoe off. That's all we did. In the second one, you compelled him to actually make an act and step into the track. That's the distinction. It's been a long-standing tradition, or I guess interpretation of Georgia constitutional law, and the court went to extreme lengths to justify that that's been the case throughout time and is still that way today, hence the finding in this particular case. Real quickly, as we all know, the implied consent law operated initially under, I guess maybe it sounds harsh, but a fiction that when you get in your car each time and go out on the highways of this state, you're making a conscious decision that, hey, if anything, a police officer gets suspicious and wants to check my blood, breath, whatever, I have given my implied consent to, by being on the highway, to do that. The court has said no. The Constitution requires an actual consent, so an implied consent that we have operated under for many years is just out the window. And that's been true, I guess they really clarified in the Williams case a little bit earlier, but it's been true for some time. What we have to have is some sort of actual consent to it. So that's what we've been operating under. But we still have that, the other part of it was the carrot and the stick, and that survives this case. The carrot and the stick is, all right, we're asking you to give a test of your blood, breath, or urine. You have the right to refuse that test, but if you do, your license is going to be suspended for a year. That's your choice, you know, the choice you make. And it's a gamble. You got to decide. Of course, I find it interesting that if the person's truly intoxicated, I don't know how they can make that choice because they're intoxicated. But anyway, that's a beside the point kind of thing. So that's where we find ourselves. The case, as I read it, the holding is simply one thing. We cannot use a defendant's refusal to take a breath test as evidence against them of guilt in their proceeding, prosecuting them for DUI, which is not a horrible thing from a prosecutorial standpoint. I understand the utility of it because it's nice to show that the person refused and stepped away. But truly, when you get down to it, the refusal to take a test is not evidence of intoxication or being less safe to drive. You know, and if they can refuse the test, you still don't have an ability to necessarily prove a per se violation of like you were above 0.08, or if you were under 21 above 0.02. You don't have that ability to prove, but you didn't anyway. Only thing you could do is say, hey, they offered a test, they refused. So that's the narrow holding that I see of this. Now, the court does intimate several things that go with us. They tell us that we can still use administrative sanctions, such as losing your license. You can still, in the course of an administrative hearing, say they refused the test, because that's the gravamen of that administrative hearing, because you're trying to decide, is your license going to be suspended for failure to give, to take the test? Well, that's the fact. Did you fail to take the test? It's not a Fifth Amendment, or excuse me, a freedom against self-incrimination. It's just a fact. You didn't take the test. So we're okay there. The court does intimate that we probably, and they've had this in several cases, but they've said it clearly in this one, that we really need to think about rewriting our implied consent warnings that are provided in statute. Granted, they only have to be substantially compliant, but the fact is they now still contain the fact, we state in there, that if you don't consent to the test, it can be used against you in your prosecution. It also says that if you don't do it, and you go a 0.8 or higher, your license may be suspended. It's going to be suspended. And they think it's only fair that we tell them what really will happen. The court intimates we need to fix that. They also have suggested there may be some other ways to go about it, but the ways they suggested as far as amending the Constitution to correct the interpretation of the right against self-incrimination that's in there, I don't think it's feasible, plausible, or wise to pursue. Wisdom, of course, is not really my thing, because that's public policy as far as where you find something wise or not. But the idea of trying to amend the Constitution precisely and not disrupt 200 years of jurisprudence just to get to a particular area may be a hill too far, bridge too far to get there. I don't really believe that this committee would find that to be an option. The only other thing that gives me some pause is the intimation also by the court that perhaps this ruling could affect the use of previous DUI convictions to prove knowledge, plan, whatever, in future prosecutions, and the potential, I kind of read between the lines, that maybe some DUI convictions may be subject to collateral attack because of the use of evidence that was obtained improperly and comments on the defendant's right to exercise his right not to incriminate himself. That's where I see it, Mr. Chairman.
Just one question, as it relates to options for the officer at the time of the refusal. Under your understanding of the opinion and the Georgia Constitution, could the officer then, without a warrant, offer for the driver to take a blood test at the time, and a refusal would be inadmissible under those circumstances?
That is the question I had, Mr. Chairman. See, we had the similar question. I don't know that the court truly addresses it. They say this applies only to breath test, which would intimate to me that perhaps if you did ask for a blood test, urine test, that you could use it that way. However, I'm not comfortable in going that far based on what the court did say in the course of the opinion. It just wasn't clear whether we can go there.
Just to draw the distinction here, with a warrant, you certainly could.
Yeah.
But we're talking about without a warrant.
That's
is
correct.
there availability? All right, Chairman Fleming.
And thank you, Mr. Chairman, and I know we have a solicitor here who can probably fill us in on some of the practical aspects, but one question that popped into my mind, if next time I get my driver's license renewed, part of that process is for me to actually consent to the fact that a breathalyzer may be used on me if an officer so thinks it necessary, would that resolve the problem?
I think it would give grounds to argue that it does, because now you're no longer implying the consent. You could be arguably obtaining actual consent going down that road. Of course, that would only be good for the people that do, and you have to have some sort of designation on the license, I suppose, that show that this is one of the licenses for which.
I mean, to make it if you want a license in the state, you have to consent to an officer asking you to do a breathalyzer test, and if you refuse, it can be used against you in court.
I agree. What I'm saying is that we would have to know as it rolled in, because the officer will have to be able to find some way to know, is this a license that's been issued that the person has been notified on? Is this one of the old licenses that has not? And if they're from out of state, it doesn't help us at all. But so that kind of gets there. I think you have that argument. I don't know that I'm totally comfortable with it, because I don't know what the court's view of that would be, that if you gave consent way back when for an event, because our licenses are way long periods for some of them, if it's still a valid consent, can you revoke that consent? I understand it's conditional on the license, and I guess if you revoke that consent, you would say the person would have to come back in and say, I'm surrendering my license because I'm revoking my consent. I think it gets you a step down the road toward there. I can't say I'm 100% comfortable that gets you all the way, but I do think that gets you down the road.
Chairman Setzler. Oh, I'm sorry, Chairman Fleming.
It's Mr. Setzler's question. I'll give him credit for it. What if when I get my tag every year from my tax commissioner, that part of that is that I consent?
Again, I think from a police officer standpoint, you're having a difficult time, because your tag and your license are two different things. I own my children's cars are in my name, and I buy the tags from them. My wife drives them, my kids drive them. Again, linking those two things for the police officer on the side of the road, I think would be
Practically is a
difficult.
problem.
It's practically difficult. Again, it gets you one step down the road if you can make that linkage and everybody hooks up. But I'm just not totally comfortable. I can say it absolutely.
Chairman.
Hey, Mr. Chairman, I just want to follow a similar line of questioning, but also ask a separate question. That at the end of the day, if someone, even if it were done as Chairman Fleming alluded to, that you do give this explicit consent for a breathalyzer test when you get your license, if the person there on roadside says, I'm still not going to do it, Does that any different than it is today, where you've got implied consent and you lose your license free? I mean, doesn't that really just get us to the same place we're at today if someone refuses to blow?
The only thing I think you might have a leg up is arguing that you could use it as evidence against them in court. Because I say, today, if they voluntarily, if you have given them the advice and they voluntarily agree to a breathalyzer, the results would be admissible, everything's fine. It's just, do they voluntarily agree to do it is the question. So yeah, I think you're pretty well back to the same spot, yeah.
I did have a question. Is there anything, it's a separate question, as we talk about what rights are read to people roadside or otherwise, and this may happen today, I don't know all these details. Is there any duty to, under our current structure, to inform somebody if they don't take the breathalyzer test, they're going to lose their license for a year? Is that ever read to anybody?
That is part of the implied consent warning.
So they do have, they are made aware of that, because I just think as a matter, as we think about administrative actions, we can call a 1-year license suspension an administrative action, but that's a hammer. That is a real, that is a punishment, if not it's a de facto punishment. And I think that as long as people know that's happening, I want to make sure nothing we do sidesteps someone knowing, if I don't blow or I don't render a sample, I'm going to lose my license for you. I think they need to know that. And again, they may be in a place where they're not making good decisions, and that's on them. Yeah. But I do think anything we do as a committee, we need to make sure people are informed of that, because to me that's one of the biggest hammers in the whole DUI structure, is losing your license for a year.
Well, just to add meat to the bones of that, do you mind if I just read you?
Please.
This is for the over 21. There's a different implied consent for under 21 than there is 21 and over. It says, Georgia law requires you to submit to state-administered chemical test of your blood, breath, urine, or other bodily substances for the purpose of determining if you're under the influence of alcohol or drugs. If you refuse this testing, your Georgia driver's license or privilege to drive on the highways of this state will be suspended for a minimum period of 1 year. Your refusal to submit to the required testing may be offered into evidence against you at trial. If you submit to testing and the results indicate an alcohol concentration of 0.08 grams or more, your Georgia driver's license or privilege to drive on the highways of this state may be suspended for a minimum period of 1 year. After first submitting to this required state test, you are entitled to additional chemical tests of your blood, breath, urine, or other bodily substances at your own expense and from qualified personnel of your own choosing. Will you submit to the state-administered chemical test of your, and then there's a blank for you, the officer, to fill in which one he is asking you to do, under the implied consent law? And that's what would be either exact words or substantially those words. And of course, the couple of issues that people run into immediately is the word submit here. I've heard people argue that before. Is not really consent. You're just forcing somebody to consent to submit something. But anyway, it does give them a pretty clear warning that that's what happens. The one that's unclear is the fact that if you go 0.08 grams or more, your license may be suspended. I think it's pretty clear it's going to be suspended. So, but anyway.
Chairman Fleming.
So I'm trying to narrow down what we lost. We lost the ability to use at a trial the fact that someone refused to blow, and that's it.
That's the way I read the case.
And I guess the solicitor can tell us the practical effect of that as he tries to prosecute these matters.
So, Mr. Chisholm, I'll recognize you.
Yes, sir. C.R. Chisholm. I'm the Solicitor General for Athens, Clarke County, the jurisdiction from which the Elliott opinion came from. The effect of this is, yes, we will not be able to use refusals of blood tests or breath tests at a trial. And the practical effect of that is most jurors, and this is based on nearly 20 years of prosecuting DUI cases in front of jury trials in Athens, Clarke County, if most jurors come in and they expect a test or some mention of a test. We have tried cases where a refusal was suppressed because implied consent was incorrectly read or untimely read. As a result, we had other evidence we thought was sufficient, put up the case, and we've done this several times. and the jury comes back not guilty. And primarily when we talk to the jurors, they say, well, we know there are tests, and we wanted to know why there wasn't any mention of a test here. So it is valuable to have that information in front of a jury, even if it is just to say that they refused to take the test. The other aspect of this that is currently in front of us is that we're not only really losing the refusals, but this has an impact on the actual breath test that exists currently. And that is the second part of all of this, because the person that has now agreed to take a state-administered breath test under this version of implied consent has been told if they don't want to take the test and they refuse, that refusal will result in a suspension, definite suspension, and it will also result in it being used as evidence against them at trial. This is now a flawed version of the implied consent warning, and that can have an effect on the breath test that we actually have obtained, and that's alluded to in the Elliott opinion, that could raise some issues, but they decline and say that issue is not before them now. So what we have been concerned with as solicitors and prosecutors around the state is what can we do in the interim to at least keep breath tests available to jurisdictions who want to use breath tests still, as well as simplifying and putting that Elliott language or keeping that Elliott decision in mind and applying it to our implied consent warning. So we have developed a language. It's substantially the same as the language that already exists. However, it informs the person that only blood and urine, a refusal of blood and urine, would result in that evidence being used against them at trial. But it keeps blood in as an option, and for jurisdictions who might not have the resources to do blood testing in every case, and also keeping in mind the fact that the GBI would have to shoulder a huge amount of cases that they're not ready to handle. Blood test would still be able to be used, or excuse me, breath test would still be able to be used. They will not result in the use of it at trial if you refuse, but it could result still, if you refuse it, in your license being suspended.
Thank you, Mr. Chisholm. And just for the benefit of the committee, let me let you know what I'm thinking about time-wise going forward. I know we're up on 9 o'clock here today, and I appreciate the testimony that we've had. What I was envisioning was we'd have a hearing where we'd hear from PAC and GACTL with their perspective on this. We'd have solicitors and practitioners, practicing attorneys who would speak, and judicial officers who would be available to offer testimony on this. We'd also have a separate committee day with an opportunity for advocates or those who have particularized knowledge here that might be helpful. We haven't, just in talking about you mentioned the impact of the GBI and the blood testing. Of course, also there's the drawing of the blood, which is many times at a hospital as well. So you have that as well, which we haven't even gotten to today. But with that in mind, just hope all the committee members know and the members of the public here that we will have further testimony after today, and so with ample opportunity for all who want to be heard with the organizations I met to have that opportunity. But with that in mind, I'll recognize Chairman Fleming for questions as to Mr. Chisholm.
Mr. Chisholm, straight to the point. What can we do right now to help you get the law back like it was to the extent possible?
To the extent possible, at this point we have a fix that we have proposed, but again, it's a temporary fix. It's to get us to a more permanent fix, but that we recognize that that's not going to happen over the course of the next couple of weeks. That's going to be, as counsel mentioned earlier, that's going to be a huge hill to climb. But this is a fix for right now that we can get us as close to where we were before the Elliott opinion. And that's why we are putting this language out, because it keeps pretty much so everything intact, except for the fact that breath test refusals can be used against you.
So you have language that
Yes,
you
sir.
need us to pass to
Yes, sir.
put you back to the best spot. So what's the long-term solution if that's a short-term solution?
The long-term solution, there's a lot of options for long-term solutions, and I don't think there's a consensus right now as what the long-term solution would be at this point.
There's not, or there is?
There's not at this point.
What's the best two options in your opinion?
Best two options, in my opinion, for the moment, it's reading for, the best option is reading for blood. That's the best option from our perspective for our jurisdiction, but that's probably not the best option for the long term.
So, Mr. Chairman, so if I hear the solicitor correctly, there's a proposal they have that we could pass, the Senate could pass, and the governor could sign that would remedy this situation to the extent possible by statute fairly quickly, is what I think I just heard.
I think I heard the same thing, and as members of this committee know, if a bill is introduced and assigned to this committee, we're going to do what we can to expedite any hearings with the rules that we have. But as long as this committee is hearing this matter, we're going to have we're going to give the time necessary to have complete opportunity to hear from all sides on this issue, so that we can make the best possible decision, even acknowledging crossover day is upon us. So, Chairman Setzler.
Thank you. To your point about reading for blood, I know it sounds like the opinion only refers to breathalyzer tests can't be used against you. Is there any reason we would think that breathalyzer versus blood that someone would voluntarily consent to wouldn't be treated the same way with the courts? I mean, it would seem to me it's a difference without a distinction. If you've got a right to not have your refusal of a breathalyzer test be used against you in court, it would seem that your refusal for a blood or any other test would follow, even if it's not stated as such in the opinion. What are your thoughts on that?
It certainly could be a tax break brought on blood test refusals. That's a possibility. But I think at this point, Justice Boggs, he said directly in his consenting opinion, this opinion does not affect blood testing. And we've had a couple of other opinions as well indicating that blood testing does not require an affirmative act on the part of the defendant. So from a case law standpoint, I think we're on more solid ground. Doesn't mean that I at this point cannot guarantee that a defense attorney or defense bar will raise issues with that. But at this time, we are on better footing with our case law concerning blood testing.
Is there any sense, and again, I've not read the opinion, is there any sense in this? I know they talk about the Fifth Amendment protections that's stated. Is there any sense in which a refusal has a prejudicial effect before a jury that has really doesn't get to its probative value? There's no sense of that in this opinion, that this person refused to consent. I know is the interaction between the officer and the accused sort of does influence sometimes how it's administered by the police, how it's viewed. Is there any reference to a prejudicial value of a refusal in court, or is that
No,
nowhere
sir.
there?
This opinion revolves squarely around paragraph 16 of our Constitution, not the Fifth Amendment of the United States Constitution.
But in paralleling, forgive me, but it parallels just that the right with respect to self-incrimination has nothing to do with any prejudicial value in court.
No, sir.
If so, okay.
Representative McLaren.
Thank you, Mr. Chairman. I'll try to be very brief. So in keeping with Chairman Fleming's proposal about let's fix what we can quickly, because I think that's a great idea, are you considering a curative jury instruction as part of your package? Because one thought that I had was, if one of your issues, the first issue you mentioned, was that there's a negative inference or prejudicial inference against the prosecution being drawn by the jury because there's no mention of testing. Would in your mind, just shooting from the hip, do you think a jury instruction that said, you shall draw no inferences either in favor of the prosecution or the defense from any lack of mention of testing in the case, or something like that, be useful to you as part of a package of something to fix it?
I mean, I think that's a possibility. In practice, it's going to be difficult, even with that type of jury charge, for folks to erase the idea of the expectation that there's a test. That's the common knowledge that jurors carry into the courtroom with them, regardless of what the jury instruction is. I mean, it wouldn't be hurtful. It could be helpful as part of a larger fix. But jurors come in, they expect some mentioning of a test because they all think that the DUI law is .08 or above. They don't understand that they can also be charged with something else called DUI less safe.
Do you think even a sentence on this case would be helpful, or some way of saying, you know, in Georgia there's a right against self-incrimination, there's a right not to blow, so if you hear no mention of testing, don't draw an inference either way? I mean, do you think that might be helpful?
Yeah, then that's indirectly then commenting on a person's right to not do that. I don't know that that would be something that we could use.
You don't think that would pass constitutional muster?
Right.
Okay. Thank you.
All right. Any final questions for any of our witnesses today? All right. I want to thank all of our witnesses and thank the members of the committee for the discussion this afternoon. Scheduling, here's what I'm anticipating. At this point, subject to change, what I'm looking at is Monday, we'll have a continuation of this discussion at 1 o'clock. We'll then have subcommittees at 2 and 3 on Monday, so we'll just do everything back to back. And we will have the next full committee, well, we'll have a hearing on this Monday at 1, but then we'll have another full committee hearing Tuesday morning at 8 to take up any bills that are passed out of subcommittee and to continue with this discussion as well. So just to reiterate, beginning at 1 o'clock on Monday, subcommittees at 2 and 3, and then Tuesday morning at 8 a.m. Thank you. We're adjourned.